Hi and assalamualaikum. My name is Nabila Natasha Miti Amanah Bansha. My matric card number is 01DKB19F1035.
Hi, my name is Sulazadia binti Marsimbang and my matric card number is 01DKB19F1026.
Assalamualaikum. My name is Wandor Aida binti Wan Hassan. My matric card number is 01DKB19F1027.
Hi and Assalamualaikum. My name is Farhana Farati binti Maksum and my matric card number is 01DKB19F1037.
Today our group will present one of topic chapter 8, Industry Relation, which is arbitration. Example case of arbitration is Felda Investment Corporation Sendirian Berhad versus Synergy Pemenat Sendirian Berhad. The introduction of arbitration is a procedure in which a dispute is submitted by agreement of the parties, one or more arbitrators who make a binding decision on the dispute. In choosing arbitration, the parties opt for a private dispute resolution procedure instead of going to court. The issue over an agreement over 24 parcels of land belonging to Felda in Jalan Semarak here between Felda Investment Corporation Sendirian Berhad FIC and Synergy Pemenat Sendirian Berhad SPSB will continue to go for arbitration. This follows the decision of High Court Judicial Commissioner Ana Ponodorai to dismiss FIC's application as the plaintiff for an injunction against the arbitration process on the issue. Amrit Paul said the court made the ruling after finding that any issue involving FIC and Synergy Pemenat should be heard through arbitration proceedings.
Next, I will continue explain about the issue dispute. The background facts essentially involve the Federal Lands Development Authority, which is Felda, and Felda Investment Corporation Sendirian Berhad, which is FIC, having filed a conspiracy suit against Synergy's Pemenat Sendirian Berhad and other alleged wrongdoers. The suit was to challenge certain contracts, including a development agreement and other documents. FIC, as a plaintiff in the originating suit on January 24, attempts to state Article 9.04 of the development agreement between the two parties on June 2, 2014, void and invalid, unused and unenforceable. In response, Synergy Pemenat commenced arbitrations proceeding against FIC based on the arbitration clause in the development agreement between Synergy Pemenat and FIC.
Okay, I'm gonna talk about the action. The first is date of the case. The date is 23 September 2020. Next, the judge who involved in this case. The first one is Anand Ponodurai JC and the second one is Wong Chi Ling. Next, FIC lawyer is Kumar Kasigam. SPSB lawyer is Amrit Pal Singh and RK Sharma. The judgment is today. The decision shows a different approach is granting an anti-arbitration order when they applying the Jaya Sudir Federal Court decision. The next action is at the first judgment, FIC file an appeal against Synergy Pemenat. One of the main aids the FIC sought was for anti-arbitration order to restrain the continuation of arbitration proceeding permanently. Since the FIC is a party to the arbitration agreement, the court ruled that a higher tax or threshold is required for an anti-arbitration order. The court could not conclude that the continuation of the arbitration would be oppressive, irritation, unreasonable, or an abuse of process. The application for an anti-arbitration injunction was denied. In the second judgment, FIC and FELDA filed an anti-arbitration order against Synergy Promenade. The relief sought is similar again to an order to restrain Synergy Promenade from taking steps of further proceed with the arbitration process. This is why waiting for a conspiracy suit to be complete.
I will continue this presentation by explaining the last part of this topic, which is solution and formulation. Solution. The FIC application to prevent Synergy Promenade from proceeding with the arbitration proceedings was rejected by the court at a cost of 25,000 ringgit. Critically, FELDA is not a party to the arbitration agreement, so different standards will apply when FELDA files an anti-arbitration application. The test will be the American Dynamite factor for the temporary order. In this second judgment, the court then granted an anti-arbitration order by a party not involved in the arbitration. The court also ordered Synergy Promenade priced at 10,000 ringgit to FELDA and FIC. Last but not least, we move on to formulation of this topic. The company demand a specific performance decision against the defendants, requiring them to comply with the agreement, as well as a follow-up order directing the defendants to immediately surrender title to the land of the parcel to the company. The statement read, apart from that, FELDA and FIC have also filed a 2 billion ringgit suit against former chairman Tan Sri Muhammad Isa Abdul Samad and Tan Sri Shahril Abdul Samad, along with various former FELDA directors general as well as Synergy Promenade, Synergy Promenade KLVC Sendirian Berhad and lawyers. Finally, a court decision states that FELDA and FIC allege that these parties together conspired to loot FELDA and FIC through illegal means, which resulted in losses suffered by both of them. Before we end our presentation, do you have any question? That's all from us. Thank you.